My goal is straightforward: to make the law usable and easy to understand for everyone. All of us in the United States have equal rights and should have an equal opportunity and a right to justice. I'm here to help because I want everybody to achieve their American dream. I'm Brad Bernstein, and this is your Decriminalization Braducation. I'm not here to tell you what you want to know. I'm here to tell you what you need to know. My objective is to make the law easy for you to understand so that you can use the justice system, know your rights, take advantage of the law, and achieve your American dream. Stop and Frisk, known as the Terry Stop. When walking down the street, what do you do when a cop stops you? And when can a cop frisk you? Now, the first thing you need to know is that a police officer can stop you on the street and ask you questions in furtherance of their policing duties. The important thing to know, however, is when you are and when you are not free to leave, when you have the right to end that questioning and walk away. So when are you not free to leave when you're stopped by the police? Generally, there are two types of stops initiated by police in which you are not free to leave. First, the obvious one is the arrest, when a police officer has probable cause that a crime is being committed by you. The officer has a right to arrest you. The notion of probable cause comes from the Fourth Amendment to the United States Constitution. It protects people from unreasonable search and seizures. An unreasonable stop by a police officer and an unreasonable pat-down would be considered an unlawful search and seizure. Now, the Fourth Amendment is not a guarantee against all searches, but just those that are unreasonable. The second time that police can stop you is the Terry Stop, or more commonly known as the Stop and Frisk. When a police officer has what is called reasonable suspicion that a crime is being committed by you, the officer may stop you and detain you for a reasonable period of time and ask you questions to confirm whether you committed a crime. But reasonable suspicion is not, I had a hunch, or something seemed fishy. If an officer stops you and ultimately arrests you because something seemed fishy to that officer, your case will be thrown out of court because it was an unreasonable stop. Rather, reasonable suspicion exists where the officer can point to specific and articulable facts, taken together with rational inferences from those facts, that leads the officer to believe a crime is being committed. Now, the origin of all of this is the landmark 1968 case of Terry versus Ohio. The United States Supreme Court announced this new rule and held that a person can be stopped and briefly detained by a police officer based on a reasonable suspicion of involvement in a punishable crime. A helpful indication from the court was its statement that reasonable suspicion must be more than a hunch. So here's your braducation within a braducation. In 1963, a police officer in Cleveland saw two men pacing by the same store over and over again on foot, looking inside. It appeared they were casing the store out. A third man joined up with the men, and they began walking toward the store. The police officer stopped them, identified himself, and asked what they were up to. When one of the men gave a mumbling, non-responsive answer, the officer spun one man around, patted him down, felt a pistol, and arrested him. The trial allowed the gun into evidence over the defense's objection, and the appellate courts affirmed. The Supreme Court also affirmed, finding the existence of reasonable suspicion and announcing this new law. Now, when does the pat, which is the frisk, in the stop and frisk, come into play? The police can only pat you down or frisk you when they think you are armed and dangerous, or they believe you are in the middle of an armed and dangerous crime. And this, folks, is where the stop and frisk is often abused by the police. If you are stopped for suspected criminal activity that is not weapon-related or dangerous, such as public disturbance, drug possession, subway fare evasion, then the stop in the stop and frisk would hold up in court, but not the frisk. Even if the cop did find something illegal on you during the stop and frisk, it may not hold up in court if they did not have the right to frisk you in the first place. Moreover, if an officer legally pats you down and feels an object in your pocket or under your clothing, it must be apparent to the officer that what he or she is feeling is a possible weapon before the officer can remove it. An officer cannot manipulate an object for some long period of time to figure out what it is. There are even cases where if an officer can tell a pocketed object is drugs, the officer cannot remove that object as contraband. The purpose of a frisk is only to find weapons. Now, two things make the stop and frisk controversial, and we got to talk about it. First, police disproportionately conduct Terry stops on people of color. There is no question about it. Second, as I mentioned earlier, police routinely conduct pat-downs and frisks absent any reasonable suspicion that a person is armed and dangerous. Here, where I practice in New York City, there has been a controversial history of the application of stop and frisk. This came to a point in the summer of 2013 when a United States District Court judge ruled that the stop and frisk practice as applied in New York City that was put into effect by Mayor Rudolph Giuliani and continued by Mayor Michael Bloomberg was unconstitutional, and the judge directed the New York Police Department to adopt a written policy to specify when such stops are authorized. This was a bold ruling. It was upheld by the Federal Second Circuit Court of Appeals, and this failed policy eventually derailed Michael Bloomberg's 2020 presidential campaign. Since the New York Police Department overhauled its use of stop and frisk in 2013, crime has actually gone down. I believe that stricter adherence to the constitutional mandate of Terry has led to far fewer stops, meaning a better allocation of police resources, far fewer detainments of innocent people, and increased the ratio of stops that ultimately produced evidence of the crime that the police stopped the suspect for. And if you're arrested by the police, you have the right to a government-appointed lawyer if you can't afford to hire one. Tune in to Bradshaw Live weekdays 6 to 8 p.m. Eastern Standard Time on Facebook and YouTube for more Braducations, immigration and legal news, interviews, fun, and to achieve your American dream.
This is general legal advice only. Ask your attorney about your specific situation. Prior successful results do not guarantee a similar outcome in the future.
Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.